Hello, everyone. Welcome to another one-on-one Talking Feds. This is a pretty special episode talking through a monumental ruling. The old curse goes, may you live your life in interesting times, and someone has certainly cursed the Supreme Court, which now, in addition to its duties, handling the petition for cert before judgment from Jack Smith, will be getting a motion from Donald Trump to review the seismic decision of the Colorado Supreme Court yesterday, holding that Trump is not qualified to be a candidate for president by virtue of Section 3 of the 14th Amendment and his having previously sworn an oath and engaged in insurrection. And that's what those terms dictate. If you've done that, you can't be a candidate for federal office. To talk this through, no one better than the Supreme Court expert who we turned to before, Steve Vladeck, who, as most of you know, the Charles Allen Wright Chair in federal courts at the University of Texas Law School, Supreme Court analyst at CNN, and co-host of the National Security Law podcast. He's also the author of the New York Times bestseller, The Shadow Docket: How the Supreme Court Uses Stealth Rulings to Amass Power and Undermine the Republic. Steve, thanks so much for being here on what I'm sure is an unbelievably busy day for you.
Always happy to talk to you, Harry.
All right, let's start here. We've detailed the opinion somewhat. I really want to focus on the high court, but you heard the oral argument, or as did I. Were you surprised at the breakdown? It's a pretty divided court, 3 different dissents basically saying we shouldn't be doing this at all. Might even say bitterly divided, notwithstanding being all Democratic appointees. Did the breakdown surprise you, and the rationales of the dissenters surprise you?
Not really, Harry. I mean, I think a couple of different things are going on. First, we're in uncharted territory. I mean, whatever else you think about former President Trump and Section 3 of the 14th Amendment, it is just objectively true that we've never had a situation where you had the leading candidate for a major political party in a presidential election, um, in any kind of jeopardy, in this space. And so, I think that's gonna push judges with different sensibilities to react differently. There are gonna be judges who say, "Let justice be done though the heavens fall." And, so my job is just to decide the legal questions before me. There are gonna be judges who think that the both low and high politics of the dispute are also relevant, and so might be looking for off-ramps to avoid, the courts being the leading, um, sort of tip of the spear when it comes to the enforcement of Section 3. And I think what you're seeing in the Colorado Supreme Court decision is a reflection of some of the divisions, even among those who are absolutely convinced that, Trump engaged in insurrection, that he ought not to be a candidate for high office, but who might nevertheless still be somewhat ambivalent about whether we really think the way to reach that result is by these state Supreme Court decisions.
Yeah, there is a central riddle here. None of the 3 dissenters challenged the basic finding, and it was made, by a trial court the way findings are normally made. But there seems to be a pretty broad consensus, certainly not absolute, that the shoe fits, as it were, that he engaged in insurrection. But I think the fundamental questions of judicial power, maybe state and federal power, are going to be looming large. So let's try to move ahead, hearkening back to what the justices of the Colorado Supreme Court said as necessary. But we now have it. It's true the opinion has been stayed, but we very much contemplate now the possibility that the Colorado Supreme Court mandate orders the Secretary of State to take Donald Trump off the ballot for the Republican primary as being unqualified. And so at that point, 49 states would have him the Republican candidate, 1 would not. Let's just start with, there's been a lot of loose talk, not to say false talk. As you say, we are way off-road and unprecedented situation. But there's a lot of talk that like, oh, it's nearly certain the Supreme Court must take this case. You can't see them not doing it, etc. Do you endorse that point of view?
I do. I mean, I would not have felt that way if the Colorado Supreme Court had, for example, just affirmed the trial court, which, as folks might remember, had ruled that Trump had engaged in insurrection, but that he was not the kind of officer to whom Section 3 applied. I could have seen the Supreme Court sitting out of that. I don't see any universe in which really at almost any modern juncture, the US Supreme Court would have sat out of, this kind of Harry, not just novel constitutional question, but novel constitutional question with potentially massive electoral ramifications on a nationwide basis. I mean, whatever you think of the US Supreme Court, like there's not much point in having a US Supreme Court if it's not going to take cases like this one.
Yeah, I totally agree. And there are a lot of in the weird period in which we find ourselves. There are small gauge legal questions that turn out to have big political impact. This is one that is both enormous, almost can't be overestimated, both legally and politically.
Right.
It's
This wolf comes as a wolf, to quote Justice Scalia.
Exactly. All right. So, but I think a very apropos quote, because there, just as you said of the Colorado justices, there will be predispositions among the justices of the Supreme Court, and if I can refer to your low and high politics, there is on the one hand, just before getting to the merits, there's the notion of the elections being decided this way. And I think there may well be many justices on the court who would be happy, relieved if Donald Trump were just somehow in some magic Deus Ex Machina way removed from things. But there are there's the sort of Republican politics of it, because it will play as a very partisan victory, and then just the bigger constitutional politics, I guess you could say. Okay, so let's say we've gotten to that point. The court will take it. And by the way, take it in short order. The stay goes until the 4th, and the primary deadline, we're told, for the Colorado Secretary of State, at least for the Republican primary, is the 5th. Logistically, do we think that the court, which already has some pressing business on its plate, is going to get all the briefing and have oral argument and issue decisions? And that'll actually be my next question to you. How many? By the 4th of January?
No. So I mean, I think the Colorado Supreme Court thought very carefully about how it structured the stay. So the stay expires January 4th unless, right, Trump has asked the Supreme Court to review the case by then. The court doesn't have to have answered, right? Trump just has to file by January 4th. And I'd be very surprised if he files before January 4th. And so against that backdrop,
if he doesn't file before.
No, I'd be surprised if he does
you think
file.
he waits till January 4th to file? Because any day of delay is a good day for him.
As long as he's on the ballot, which, to me, like waiting until the 4th only increases the odds that he's on the primary ballot. I think he waits. Harry, I think the Colorado Supreme Court structured this ruling so that Trump will be on the primary ballot in Colorado. And so that basically the US Supreme Court can resolve the issue quickly, but not in a context in which everyone's hair is on fire. Right? Not perhaps in contrast to the Jack Smith immunity issue. Right? Maybe the court can take 6 to 8 weeks, right, to resolve this case. Right? Just so that, by a week before the actual primary, which I think is March 5th in Colorado, right, there's some resolution. And even if not that, I mean, right, the real question is not, can Trump be on primary ballots? The real question is, can he be on the general election ballots? I could imagine a universe, Harry, where the Supreme Court feels sort of a loose sense of urgency, but not a incredible sense of urgency, especially because the status quo will be Trump is on the ballot.
Yeah. Okay. So I see that. That's an important clarification. Um, Query whether the holding is itself authority for saying he can't be on the general election ballot. But with all the unanswered questions, let's
No,
put
no,
that to the side.
it's worth playing that out. I mean, so imagine the Supreme Court says come January 6th or 7th, right, that because the ballots have been printed, the matter's now moot, right? Um, Everyone knows that this dispute would immediately recur in the general election cycle between the same parties, and so I don't think there's a really plausible argument that that the case will get mooted if the court doesn't rule by January 5th.
No, but
Um,
isn't there a strong argument that it's already been decided? In other words, if the court were to just do nothing, you don't think? Well, I guess
I
they
mean, that, I mean,
at
I
the
mean, that, I
minimum
mean,
have to issue another mandate to the Secretary of State. I guess, right?
yeah, I mean, as of now, the status quo is Trump is on the ballot in Colorado.
Right, right.
And that status quo is going to persist through the primary as long as Trump files his appeal in the Supreme Court by January 4th. And so, I think the justices are going to have enough to worry about without sort of disrupting that status quo.
And will they? Does that mean they won't need five? They won't have to enter a stay in order to keep it that way. Is that correct?
As long as Trump files by January 4th, the stay issued by the Colorado Supreme Court remains in effect until the U.S. Supreme Court rules. And so, going back to sort of the Colorado Supreme Court, so someone thought this through, right? I mean,
Yeah.
this really, it's not just that they issued a stay, it's how they timed the stay so that it doesn't like directly moot the appeal, but it will practically take the stake, lower the stakes. Which leads me to think that, like, yes, the U.S. Supreme Court will take this up, but like maybe, late January, early February, as opposed to like next week.
Yeah, that's an excellent point. And also, as to the Colorado Supreme Court, it's going to play in the press as shades of Bush v. Gore as nakedly partisan, but it's a pretty careful, methodical, thought through, and all in all, canvassing of many different kinds of considerations. All right, so let's now move. Let's say the court takes it. They take it with all deliberate speed, but not with, as you put it, hair on fire speed.
Or from Spaceball's ludicrous speed.
Right, exactly. I'm trying to think of a subtle or nuanced way to say it, but what the heck? Let's just pull the trigger. Does it seem very unlikely to you that the court affirms? Or, well, they've already taken it, so that's the other thing they could do to leave it undisturbed. Does it seem very unlikely to you that the court affirms the Colorado Supreme Court?
Yes, I mean, this is in my newsletter on Thursday. In One First, my Supreme Court newsletter,
Which is highly recommended. I am a subscriber, a paid subscriber, as I'm not to that many things. It's really a good one, guys, and the Supreme Court really is going to matter. So anyway,
this is
a
unfortunately true.
unsolicited plug. But go ahead, Steve.
So, I think this is an object lesson in the difference between law and politics, and the extent to which law really always is informed by politics. And I'm reminded, Harry, I mean, well, the Watergate tapes case that the Supreme Court decided in 1974. And the Watergate tapes case is this remarkable moment because the court issues a unanimous decision in the name of Chief Justice Warren Burger, who Nixon had appointed to the court, that simultaneously recognizes a remarkable constitutionally grounded executive privilege and then invents a preposterous reason why it doesn't apply to Nixon. And as I like to tell my students,
and
right?
It's unanimous. And I'll just
unanimous.
add, I know you're about to tell a story, but I'll just add that Brett Kavanaugh named it as one of the 5 shining moments of the court when he testified. But there's a story goes with it, as Damon Runyon says.
No, but the Kavanaugh point is spot on, right? Which is it is widely perceived as a really powerful and important and appropriate decision by the court when, Harry, the merits of it suck. Like the defense of a constitutionally grounded executive privilege is remarkably thin, and the justification the majority proffered for overriding it doesn't stand up to even the slightest scrutiny, right? The prosecution's need for evidence in a criminal case, as opposed to the defendant's need. But we celebrate it anyway because everyone accepts that as an exercise of real politics.
More than that, of an independent judiciary, right?
Yes, 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 yes. No, no, right. But that the actual merits of the legal questions were less important than the symbolism of an independent court led by Nixon's hand-picked Chief Justice unanimously standing up to Nixon. And insofar as that's a lesson, it's a lesson that sometimes the law is not the only thing that matters. Um, and I think that I come back to that when thinking about this decision because I think the Colorado Supreme Court is ultimately right on both of the big legal questions. I think Trump did engage in insurrection. I think he is. Like, I think the presidency is covered by Section 3 of the 14th Amendment. But boy, Harry, I like, the one thing that I think no one can dispute is that this is all novel. And from a sort of high politics perspective, I would so much rather Trump lose being on the ballot in all 50 states than Trump lose in an election in which a handful of states kept him off the ballot through this novel invocation of a 155-year-old constitutional provision that no one had ever heard of before. Not because the Colorado Supreme Court is wrong, but because sometimes the law is not the only thing that matters. And so, I think there are going to be justices who feel that way too. And I'm not sure that that's going to be just the Republican appointees either.
Yeah, there is so much to unpack there, but let's start with what struck me. I mean, your last comment raises a very intriguing possibility that Roberts will be able to marshal an overwhelming, if not unanimous, court, and that itself, in terms of the political or judicial politics stake here, is the difference between a 5-4 Bush v. Gore setting,
or 6-3 Republicans versus Democrats.
Yeah, and right. And so, but for that to happen, though, there must be some cleaving apart of party identification from legal identification.
And Harry, and as in Nixon, there has to be a compromise. And so, right, the question is, what does that compromise look like? And I could describe a couple of variations of the compromise. They all end up in the same place, which is Trump is on the ballot.
Yeah, so I see that, and let me lay out the a menu for you as I see it, and let's discuss. There are a couple fairly clean and fairly well contained kind of constitutional interpretation maneuvers they could make. One would be to resuscitate the idea. Well, you gave the two issues. Maybe officer isn't covered there, and if you're thinking in the grandiose terms, and I don't say that
the presidency
as a bad
is
way,
uniquely right. The presidency is uniquely excluded from the operation of Section 3.
Exactly, and you can see the argument why it would be. Trump's brief actually, man, does it vary in quality, his papers, but he had one brief that actually made a plausible argument that that's up to the people alone as a national kind of argument. So, but one would be officer. The other would be, it seems to me, definition of insurrection, which was somewhat loosey-goosey in the Supreme Court and fairly expansive in the court below. So both of those would be very anchored in text, and maybe if you're looking for a compromise, it's that. But I think the bigger action here, the thing that will engage their thinking and the welter of considerations that have determined the cases to date, say in Minnesota and Michigan, is this fundamental question of judicial power. Is this for us to do? And I'll just add one little wrinkle, which I'm sure you'll see, but after the table is set, I hope we can go through it. Which is, it's a state court opinion. It'd be one thing for the Supreme Court to say, as it did say in the gerrymandering cases, we don't think we should have a role here. It rather has to find that as a matter of federal constitutional law, a state court may not have a role in making that determination
Well,
either
yeah,
under state
yeah.
law. But those are all part and parcel of a judicial power.
I mean,
And
there's one more. I mean, so there's one more offer. I mean, I don't think it would be about state courts per se, Harry. I think it would be the argument that Section 3 is not self-executing, and so it can't be enforced by any court, right? Federal court, state court, traffic court. Um, the other off ramp is the political question doctrine, right, which is a variant of the non-self-execution argument. Just that, like, this is not the kind
but
of
Steve, you
dispute.
would know this better. Is it clear that the political question doctrine binds the state courts?
So it is not clear, but insofar as the state court was relying upon the federal constitution, um, the Supreme Court holding that the federal constitutional provision is not judicially enforceable, might at least be persuasive authority that would require remanding to the Colorado Supreme Court. Listen, it's worth saying out loud. I mean, none of the off ramps are slam dunks.
Right.
The
And you've mentioned the need for a possible compromise just
Right.
for the court needs its case like a hole in the head, right? I mean, this is a case.
So this is the first thing to say, which is I actually think the court was desperately hoping to not be in this mess in the first place.
Oh, totally.
And that the Colorado Supreme Court has just totally forced its hand.
Yeah, right? All 9 of them were like, oh shit, yesterday,
yes,
right?
I think that's right. So on non-self-execution, I mean, the last sentence of Section 3 strongly implies that it is self-executing because it says Congress can remove the disability, right?
Can you just spell that out? I think that's right, but explain a little.
So the fight is over whether some independent procedure has to happen before a court can say, yes, you are not eligible to be on the ballot, like a criminal prosecution or some other adjudicative proceeding. And, first of all, we have tons of evidence that that's not how Section 3 was enforced. The principal way it was enforced, at least in the early years, was the House and the Senate refusing to seat individuals who they believed were in violation of Section 3 from the Confederacy. But then there's the last sentence. So the last sentence of Section 3 says, Congress may, by 2/3 vote of both chambers, remove said disability, i.e., like Congress, through a 2/3 vote of both chambers, what's called a concurrent resolution, right? Congress can basically override the disqualification. Well, what is Congress overriding, right? I mean, like the clause sort of presupposes that Congress is that's something that you are just already disqualified, and Congress is removing the disability. So that argument's not obvious. The officer argument, which has been advanced by these two professors, who I think are not the most careful of scholars, is not especially persuasive when you consider whether, we really think that Section 3 was not meant to prevent Robert E. Lee or Jefferson Davis from running for president in 1868. I mean, really?
No, I think you got to take original meaning into very far, basically,
right.
And that maybe Gorsuch says something like that.
You got to accept that these are. I mean, so back to Nixon, you have to accept that our goal is not right. Legal persuasiveness is not necessarily the only goal here, and so
huge point. Yeah.
Against that I mean, so imagine a decision from the Supreme Court where you have 9 justices saying, Section 3 doesn't apply to the presidency, right? And then you've got 6 or 7, right, saying, but Trump did, we believe Trump engaged in insurrection, right? And so the headline out of the Supreme Court is, Trump engaged in insurrection, but can remain on ballot, right? That's a pretty powerful compromise. Like, hey, American people, you are the ones who have to make the decision. But we, the Supreme Court, are telling you when you go to the ballot box that, this guy over here did an insurrection.
And what would be even the possible justification, even tissue thin, for having that whole first half part of the opinion?
I mean, it would be dicta, just like the holding that Article 2 protects a constitutional executive privilege in Nixon. I mean, right? So when I teach Nixon, I mean, this is why I think Nixon's such a helpful foil, right? I teach my students, listen, all the court had to do to reach the question of whether Nixon could invoke executive privilege was assume without deciding that executive privilege is a thing. And instead, they decided it was a thing, right? They didn't have to, right? It was arguably unnecessary to the result. And so, Harry, it would technically probably be dicta.
And that's why you say 6 or 7, right? Alito and Thomas would be, having a field day on the other side, right?
Or they write a short opinion saying, we just don't think we should reach this question, right? Which would not be insane. But like, if the headline,
although I do want to I have a follow-up
Yeah.
question on that hypothesis, but go ahead.
But like, I mean, I just in a world in which the Supreme Court says, listen, we're not going to keep Trump off the ballot, but we do think he engaged in insurrection. I think all masters are served. I think the choice is left to the American people in the democratic process. The Supreme Court will have done its bid to sort of clarify that, yes, there was an insurrection. Right. This court will have said that. Like, it's such an elegant compromise that will make no one happy, but that is the kind of compromise historically that defined those kinds of landmark separation of powers decisions.
So that's a super interesting surmise, and even
Which is why it'll never happen, by the way. Like,
yeah, I hear you. But what I think the broader point here is that maybe in the service of bigger fish to fry than just the legal question, which is already pretty big, some supermajority of the Supreme Court coalesces around a result that wouldn't necessarily cut it if it were a statutory interpretation ERISA case, but they'll because they see the consequences. Okay, I just want to say I do think the judicial power questions are going to be very big, and there are some things that the court could say that wouldn't go far enough to actually disable a state court from making the determination. But we've sort of covered that. Now, let's end here. You probably have too listened to some of the commentary on TV. Seems to be a fair bit of sentiment out there that's quite sanguine about the prospect that the court would just affirm here. So I guess a two-part question. One, were it to affirm, wouldn't the result simply be that Colorado, but no other state? I mean, there's not a scenario here where they announce in a binding way for all 50 states that he's off the ballot, I think.
No.
And then second, I take it as basically wishful thinking. I just the courts actually affirming, however you want to slice the different considerations in front of them, strikes me as remote. But I want to do a reality check on that because lots of big shots, lots of well-regarded people on TV seem to be suggesting otherwise.
I mean, I wish they were right, but it's really hard, and I spent a lot of time, right, studying and thinking about this court and some time practicing before it. It is really hard to see a universe in which there are 5 votes for a straight affirm. And it's worth thinking about the consequences of a 5-4 straight affirm if there's a nasty dissent, right? I mean, like this goes back to the high politics
Gore, right? Yeah.
And so, right. So, I think 2 things are true. I think that like there are good arguments as a matter of pure legal interpretation for why a straight affirm is the right answer on the law. But I think that the justices are not going to be thinking about it that way. And, for better or for worse, I think the justices are going to be thinking about what's the best answer for the court as an institution and for the country. And
maybe that is the right way to think about it. I think you're suggesting, yeah.
Well, so I mean, I'll say, like, I think this has been a divide, right, increasingly between liberals and conservatives about what the court's role is, right, and it's been, one of the conservative defenses of originalism is that politics should not factor into constitutional interpretation. And I think this is a really good example of how it's really kind of impossible to do
balderdash, to use a conservative term for that, right?
Politics is everywhere.
Yeah.
And maybe low politics shouldn't be part of what the court is doing, but it's impossible to divorce the court from high politics. And that to me is the conundrum that especially presents itself to the conservative justices, which is that if you just want to do law here, kind of hard to exonerate Trump. I mean, you could do it. You could say, well, there's no clear definition of insurrection. But I don't know that there's a lot of support on the Supreme Court for trying to say Trump didn't misbehave on January
Right.
6th.
Right.
Um,
All right. And this is all really it's thematically the biggest point, but there is this one little hanging chad. You did nod, but I just want to be clear. Your view is that if they were for some reason to affirm, the state of play would be that he's not on the ballot in Colorado, but that doesn't say anything about the other 49 states unless they themselves, follow suit in individual proceedings. Yeah.
Right. So there would be some secretaries of state that would voluntarily sort of take it upon themselves to kick Trump off the ballot in light of a Supreme Court decision that says he's ineligible. And there would be some secretaries of state, like here in Texas, who would have to be sued. And so you would have litigation where state and federal courts would simply have to apply the U.S. Supreme Court's, Colorado decision to the election laws of their own states.
But even though that decision has to rest in some respect on the evidence that the Colorado trial court took and considered, et cetera, right? I mean, it's not automatic that if it's.
I mean, I think that's right. I mean, I think that's going to be part of what is going to give the Supreme Court qualms about affirming, because then you have a situation where one state trial court gets to make factual findings that have nationwide implications. Wouldn't be the first time, Harry, but this all goes to why I think at the end of the day, the most likely scenario is that Trump is on the ballot in every state come November, but maybe the Supreme Court takes some pot shots at him along the way.
Yeah, so interesting. Well, I got two things to say. Happy holidays to all, and oy vey. Thank you so much for clarifying this for us, Stephen. It's going to be, on developing in somewhat quick, if not, as you say, split-second timing. And I hope we'll have the chance to talk more about what happens as the case develops.
I picked the wrong week to care about the Supreme Court, Harry.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.